What I'd like to do today is talk about surrogate decision making. Surrogate means on behalf of someone else. And so in this case, we'll be talking about healthcare surrogate decision making. That is, if your mind is gone for whatever reason, who would make healthcare decisions for you, including end-of-life decisions, if you were in one of those relatively rare situations. And what you have in front of you is a very fancy folder, and the folder is where people are supposed to put their important estate planning documents. And in there is a planning for the family tree legal financial planning guide. This is sort of estate planning 101. It is not emphasizing taxes. We just sort of made a decision that that would really clutter things up. So there's a little bit about taxes in there, but it's really more about wills and trusts and probate and disabled children and nursing home costs, etc. Also, there's our very fancy pen, which has our name on it, and you should make sure it works if you're going to be filling this out. It should work. And also there is a blank advance directive. And this is what we're going to talk about today. Now, this blank advance directive is not the statutory form. It is the statutory form, meaning written by the legislature of the state of Oregon, with a lot of bells and whistles. In other words, we sort of doubled it in length, length, not necessarily quality, better quality, but not necessarily double in quality. And so what we're going to do is I'm going to give you an introduction to advanced directives, and then we're going to kind of work through it. And I want you to feel free to ask questions at any time. There's no crummy question, there's no interrupting me, just come at me. Just ask whatever you want. I'm completely comfortable. What do you have to say here?
Well, I live in Washington. So
So that's a great threshold question. So this is the Oregon statutory form. And the U.S. Supreme Court said that any form is good anywhere. All you need is clear and convincing evidence of your intent, which basically means completing a form. So it's good there, but the fact of the matter is that there are two forms in Washington that you should consider. One is essentially a power of attorney for health care, and the other is essentially an advance directive. Those two together are this form, although this is the Oregon form. Oregon has compressed both those concepts into one. So if you had this form, it would work, just like if you had the Oregon form and you went and visited your parents in Arizona, it would work in Arizona, etc. But it's usually better to have your state-specific form, particularly if you are not always in Arizona. Okay, so I think the place to begin with is the basic concept that the law we have in the United States derives from the English common law. And in the English common law, like every place else, in order to receive medical treatment, you must consent. Now, sometimes the consent is not express. So the doctor doesn't say, "John, may I touch you?" Right? I mean, you go into the doctor and it's presumed that he's going to touch you and you're not going to complain. Although if you said to the doctor, "Don't touch me," that doctor cannot touch you. So there is something called informed consent. You are consenting to treatment. Now there are exceptions to that. For example, and there are also limitations. So for example, if you are found in an automobile accident without consciousness, a medical technician can touch you and treat you and do everything that she or he can to make you better. And there are other exceptions. For example, there are very rigorous rules about electroshock treatment in a psychiatric facility. And we know that there are very rigorous rules around abortion. So there are exceptions to this general rule of consent. But that's the basic rule of consent. What we're talking about is not your consent. We're talking about you appointing John to consent on your behalf. And that's a little more complicated because John might not like you now, since you threatened divorce yesterday. It's a little more complicated. And that's the document that we're going to talk about, okay? Questions at any time. Now, a threshold for executing any document is knowing about the document. You have to have capacity. And so one of the things that this isn't right for is, for example, a mom who's 92 years old and has Alzheimer's, she cannot, of an advanced stage, she cannot at that point sign a document. Also, there are other infringements on capacity, like fraud. Mom, sign here, and it's not what you say it is. Or undue influence, like mom fell in love with the cabana boy, and she appoints the cabana boy, and her 3 kids go, God, he's been in her life, 20 days, and he's taken $20,000. Well, perhaps that is undue influence. So there are exceptions to the idea of capacity, but to sign this document, you have to have capacity. Now, the background to this document requires some history, okay? And the history is summarized in 2 cases, and you know the names of the 2 cases. I'm just kind of walk you through the law of these 2 cases. Anybody here not heard of the case of Nancy Cruzan? Nancy Cruzan is a case that went to the U.S. Supreme Court. Nancy Cruzan was a 25-year-old who in 1993 lost control of her car and ended up being tossed from the car in a ditch face down. When she was found, there was no heartbeat, no response, no pulse, nothing. It was determined that she had anoxia, which means not enough oxygen to the brain, and shortly thereafter she was diagnosed as having quote-unquote permanent brain damage by a neurosurgeon. Well, amazingly, they plugged her into artificial nutrition, artificial respiration, and she survived. And she lived in this essentially comatose state until 1988. In 1988, 5 years later, her parents, not the estranged husband, petitioned the Missouri courts to be appointed her guardian for the purposes of withdrawing life support. And this was done because the nursing facility in which she was in didn't want to do it. And it all went to court, and they won. But the Missouri the state of Missouri, exercising its authority as a state, protecting the life of children, protecting the life of the elderly against abuse, and protecting the life of people who are incompetent, stepped in and said no. And there was a protracted court fight. And that court fight ended up in the U.S. Supreme Court, the Nancy Cruzan case. And the U.S. Supreme Court had to decide whether or not an individual has the right to die. That is, exercising the right to consent through a surrogate, in this case, a guardian. Can they choose to say, I don't want artificial nutrition, I don't want artificial hydration, I don't want artificial respiration, etc. And the U.S. Supreme Court said, yes, a person has that right to make that decision, even through a surrogate. The U.S. Supreme Court also had to decide how much evidence it takes of this person's wishes in order to exercise that right to pull the plug. And what the U.S. Supreme Court came and said was it has to be clear and convincing evidence. So not just mere evidence, not a preponderance of the evidence, which is 51%. It's got to be more than 51%. So that if you lined up a bunch of people and you asked them, they said, this is more than 51%. It may not be 100%, but it's closer to 100% than 51%. And that was a groundbreaking case. And that was for the United States. I mean, these issues have been fought in other countries and with different conclusions. Generally, as we know, Northern Europe tends to go more liberal and much of the developing world tends to not. So that was the first case, the Nancy Cruzan case. The second case was the Terri Schiavo case. So everyone's pretty much heard of the Terri Schiavo case because it was not groundbreaking, but it was a media sensation. It was in the news for years. Terri was a 27-year-old. She was married, and in 1990 she had a heart attack, which again left her with no pulse, anoxia, lack of oxygen, and in a coma, which then they said was a persistent vegetative state. So the difference between a coma and a persistent vegetative state, and I'm not a doctor, so this is clearly not in medical speak, is that basically in a coma you are completely unconscious. But in a persistent vegetative state, you aren't necessarily conscious, but you can sort of bob and move your head, and there's something going on. Now, in Terri Schiavo's case, there were 14 appeals to 5 separate lawsuits. And the amount of medical evidence and the number of doctors that testified and the number of MRIs and assessments was extraordinary. And basically, the MRIs, or CAT scans, or whatever the medical equivalent was, showed that her brain had hollowed itself out in the middle, and there was just essentially no way that she really could process thought, even though there were some movements that suggested she might be responding to stimuli. So the fascinating part about the Schiavo case is that there was a lot of extraneous stuff. She was married. I don't know if the marriage was good or bad, but during the 8 years between she had the accident and this started with her husband going to court again to become her guardian to withdraw life support, he had another affair, or another relationship, excuse me, and he had even a child. But he stayed married, and he received money from something in the accident. So there were a lot of complicating things. Now, on the other hand, he stayed married to her, he said, because he wanted to make sure her wishes were met. And the truth of the matter was that, staying married to her, he was also economically on the hook for her care. So there were all these other things going on in that case. Well, basically, he petitions the court of Florida to have her feeding tube removed. And the court of Florida has an evidentiary hearing, based on the Cruzan standard. What were her wishes? Was there clear and convincing evidence? Was he the proper person to be making these wishes as a surrogate on her behalf? And the court concluded many times, yes. Well, and I don't know all the travails of the cases and the appeals, but at one point, the state legislature of Florida, the House and the Senate passed laws giving her the right to be on the feeding tube. And Jeb Bush, the governor of Florida, signed that law, a law for an individual. Well, the probate judge in this little county in Florida says, you can't do that. We can't have a law that says Sam Friedenberg is going to be special. You can't do that. And he said, that's unconstitutional. So what happened? Well, the U.S. House of Representatives, the U.S. Senate, and President Bush flew in from his retreat in Midland, Texas to Washington to sign a law giving her the right to be back on life support. And you know what that probate court judge did in Florida did? He said, you can't do that, and I have to think about the internal strength that this judge sitting in a little courthouse somewhere in Florida had to have to be doing this. It became a media sensation, but eventually the husband was able to prove her intent, clear and convincing evidence, that he was the most appropriate person, notwithstanding all those facts. And the feeding tube was removed, I think 7 years later. And think about the legal fees wrapped up in this. Now, on the parent side, because they were so in the Nancy Krizan case, it was kind of the state of Missouri that stepped in. In the Schiavo case, it was the parents who stepped in, although obviously the legislatures, et cetera, also stepped in. So, so basically what happened is she passed away something like 12 days after the feeding tube was removed.
Was that 7 years after the 8 years?
So the accident was in 1990. The process to begin the removal of life support was in 1998, 8 years. And the tube was removed in 2005. So you do the, I mean, unbelievable media sensation. So those two cases basically provide the background to what we're going to do today, because when the U.S. Supreme Court in Krizan said you need clear and convincing evidence, well, there are a lot of ways to get clear and convincing evidence. I could take an ad in the Oregonian and I say, hey, by the way, if I ever fall off my rollerblades, hit my head on a curb, I don't want life support. That would be a little dramatic, wouldn't it? Usually we have conversations with our spouses and our loved ones. The great thing about conversations is that people can get up on the stand and say, this is what Sam said, this is what Nancy said. The weakness of conversations is that it's subject to all the errors of memory, and we know, based on what happens in criminal defense cases, that there's a lot of problems with memory. So the bottom line is that clear and convincing evidence means doing a document, and that is the source of these documents. Now, the form we're going to complete is not a lot of things. It is not an authorization to have your life ended under the death with dignity law. In order to have your life ended under the death with dignity law, you must do it. You cannot have a surrogate. You must be competent and not clinically depressed. So it's not that, okay? It is also not a POLST, a physician's orders for life-sustaining treatment, which is another little form that you complete when you're actually in a hospital or in a nursing home or getting serious treatment at home, saying, this is how I feel now. Or the surrogate, the person who you've named in this document, signed to say, this is how I feel now about this particular course of treatment. This advanced directive is more signing it out, putting the loved one in the driver's seat, and saying how you feel about something that might happen down the road. This form is also not applicable to temporary situations. So I literally tell you that if you go down and buy this form at the Stevens Nest Legal Stationery Store form at Southwest 4th in downtown Portland, fill it out, have it witnessed by the Archbishop of Canterbury and the Pope, duct tape it to your chest, facing out, walk out the street, and fall, smashing your head on the pavement with the form facing up. When the EMT showed up, they're still going to do everything to try to revive you, because this is not about temporary situations. This is about situations where things have stabilized and two physicians determine that you are in one of the very crummy end-of-life situations that are stated in the form. Any questions about that? Because that's like a question I get all the time. Okay.
Well, what was the first one you gave 2 points? This one's not for temporary, and the other was...
So this is not for death with dignity. It's not a POLST, and it's not for the temporary sickness. Not to mention that the loved one you appoint isn't going to say, "Oh no, I'm done with him. Don't give him treatment." I mean, but there are built-in institutional safety standards. Okay. So what is this for? That's what it's not. What is this for? Well, this form is, number one, it's a power of attorney for healthcare. I, Sam, if I've lost the ability to formulate thought, appoint you, Sandra, to make healthcare decisions on my behalf. And this form has an alternate and a second alternate. The The statutory form only has one alternate. So if you have 2 kids you want to appoint, that statutory form doesn't work for you, unless you jerry-rig it. The second thing this form is, besides a power of attorney for healthcare, is an expression of intent in 4 very crummy end-of-life situations, which we will talk about. So it's a living will. Living will is like calling a car a sedan. It doesn't tell you what kind of sedan, it just gives you a general idea. So this is a living will. And the third thing that this form is a HIPAA release of privately protected medical information. Because there's a law that says that if you execute a form that is valid under state law, then the person who you name in the form can access your HIPAA-protected information. Now, I'll put a little caveat around that. Medical providers frequently are reluctant to provide medical information to surrogates. And it's, a combination of the fact that they are safeguarding privacy rights, which is completely understandable. And the other factor is that sometimes they don't know what the heck they're doing, which is also understandable because not everybody knows what they're doing all the time. And so even though this form does do that, sometimes you do have bumps in the road and you have to push for that information. So having said all that, let's turn to the form. This is the form. Again, this is not the statutory form. This is the statutory form plus bells and whistles, so it looks a little different than what you would get if you went to the Oregon legislative statutes and copied them on your computer. It's called the Advanced Directive. And are we going to sort of do this as we go? Okay. So, and again, you don't have to sign it. Now, the first thing remember I said you have to be competent. So, we're going to answer a few questions, okay? Everybody, what day of the week is today?
Saturday.
Very good. What city are we in?
Portland.
Okay. Where do we bank?
James.
Oh my God. Everybody. Who's president? Is he a good president? Incompetent. Okay, and if you are going to sign it, you're going to need 2 witnesses. So you're going to, look left and right, or there you can, because these are going to be the people who are witnesses. Now, again, you don't have to sign it, obviously. Okay, so put your name up at the top. First name, middle initial. And then turn the page and put your name, birth date, and address. And actually, once you put your name, you can fill out your name and address later, okay? Okay, now, immediately under there, it says, unless or revoked or suspended, this advanced directive will continue for. And you have 2 options, my entire life or a shorter period. So what I tell my clients is, choose initial, because you don't check, you don't X, you initial, my entire life, because why build in obsolescence? It's not like you're going to set your Google Calendar to 2 years from now and redo it, right? So then we get to Part B of the form, and Part B is called Appointment of a Healthcare Representative. That is a fancy way of saying appointment of a power of attorney for healthcare. So why don't you put who you appoint in that little blank there, and you can add in addresses and telephone numbers later. So ordinarily, we appoint our spouse if we're married. Even if perhaps we married late in life, keep our assets separate, really don't intend to bless them with an inheritance. But we tend to appoint our spouses. If we don't have spouses, we tend to appoint the child who we feel is most appropriate for the job. He or she has to be over 18, and if they're barely over 18, you might think about that. But here, we're not talking about money management, we're talking about the person whose values align with mine. Now, we all have children, and we all know that same child, same parents, same household, same schools, radically different people, right? And we know that sometimes we sort of feel like, well, so-and-so is I love this child a lot, but oh my God, I love this child a lot, and I get it. We have similar values. We vote the same, we see things the same way. So you have to make that decision. That is yours to make. And sometimes that's a tough decision. So you're going to name one. Now, have you got an alternate? You know, do you have someone to stick in that second blank that says, I appoint so-and-so as my alternate healthcare representative? We do not appoint trust companies. We do not appoint our stockbroker, our banker, our accountant. These are healthcare decisions. Okay? Now, the line that follows is very short and very important. I authorize my representative or alternate to direct my healthcare when I cannot do so. When I cannot do so. So implicit to this is your mind is gone. This is different than a financial power of attorney, which typically is not contingent on your mind being gone. Why? Because a lot of times we're competent, 92 years old, unfamiliar with technology, unfamiliar with the healthcare insurance billing system, and we need a power of attorney to help us. So a financial power of attorney usually is not contingent on your mind being gone. But a healthcare power of attorney like this is. So your mind has to be gone. Okay? Directly below that, you'll see number 1, limits, special conditions, or instructions. So the legislature, Oregon legislature, in its wisdom said, oh, well, when you appoint your spouse or your child, you're going to want to put a limit on things. Well, nobody wants to put a limit on things. You know, they want the child or the spouse to have authority to do the right thing in these very dire circumstances. So what we did is we added a whole bunch of words. So let me kind of give you an example. Paragraph A there is, I authorize my agent to get HIPAA protected information. We actually put it in the form, so it's obvious to whoever your health insurance provider is, presumably. B, to request whatever information is necessary to make the right decision. C, to execute the releases for that information. D, to employ and discharge medical personnel when they're not doing their job. E, to give or withhold consent of ordinary medical procedures or significant medical procedures like surgery. F.
Just so that says to give or withhold consent to any medical procedures.
Yes.
And you said ordinary procedures. Is there a difference?
Well, any would be ordinary and not ordinary. So I said ordinary and extraordinary. So yeah, no. So that's I meant to say all.
Okay.
Excuse me. F, to change my course of treatment. G, to consent to pain-relieving drugs, even if they're unconventional or addictive or something like that. H, to sign the necessary releases. So these are an attempt to put into words things that might come up, and perhaps a medical provider saying, oh, well, I'm not sure you're actually authorized to do this. Well, look, it's in writing. Okay? Now we turn the page, and there are 3 blanks on the left. And you're supposed to initial them if they apply. The first blank says, I have executed healthcare instructions. Now, you haven't. But if you turn the page again, you'll see the next section is called healthcare instructions. And presumably you will execute healthcare. The legislature just used the wrong tense on the verb. So, if you're going to do it, you would initial that. The next blank says, my representative may decide about life support for me. Now, it doesn't say my representative is going to put me on life support. It doesn't say my representative is not going to put me on life support. It's just delegating authority. I appointed my loved one, and they may decide about life support for me if the situation comes up. Now, if you don't have to initial that, But really, that's the objective of the document, that if your situation is such, they would decide about life support. And life support, for the most part, is a respirator or a ventilator or a tracheotomy or something like that, right? Remember, questions at any time. The third blank is, my representative may decide about tube feeding for me. Now, here's an interesting distinction. Respirator, ventilator, tube feeding. So, according to the U.S. Supreme Court, there really isn't a distinction between those two things. You know, they both require a person who can't do them. They both require a sterile environment in which to provide them. They both require some sort of fancy technological machine. They both require some source of power. But the Oregon legislature and a lot of people, a lot of people, completely, I think, understandable, think there's a difference. And I just, for example, learned, and I can't guarantee this, with a client in Costa Rica, that in Costa Rica it is custom for a person to be taken off a respirator or a ventilator, but never tube feeding. There is a distinction between those two. In the US, or in Oregon, they've made the distinction, but most people tend to put it under one category called heroic measures that are keeping me alive, even though my mind is gone. Because remember, this is only if your mind is gone. Questions? So then, if you were going to sign this, you would sign in date there, but we're probably not going to sign this today. Your call, you need the 2 witnesses. Okay, so then we turn the page. So we've now ended the part of the document that puts someone in the driver's seat if your mind is gone. Okay? It's like the power of attorney for healthcare part. We turn the page to part C, it's called healthcare instructions. Now, healthcare instructions is just a fancy way of saying what I want if I am in one of these really, really, really crummy end-of-life situations. That's what the health instructions. It's not really health care instructions, it's end-of-life health care instructions. And you will see 40% down the page, there's a line that we have chosen to put in bold, and I'm going to read that. Here are my desires about my health care if my doctor and another knowledgeable doctor confirm that I am in a medical condition described below. So, like so much in life, it's good to have checks and balances. And your first and foremost check and balance is the person who you appoint, because they're the person who's going to love you reciprocally and do what you feel they would do for you. But your second check and balance is having your doctor and another knowledgeable doctor confirm that you are in one of these conditions. So your mind is gone, loved ones in a driver's seat, and 2 doctors confirm the situation. Not really a situation prone to error. Okay? So then what the legislature did is come up with four specific factual situations and 1 general situation. And we're going to go through the 4 specific situations before we actually turn to the options within them. Okay? The first is called close to death. You with me? If I am close to death and life support would only postpone the moment of my death. So that means death is inevitable. Anyone been in a philosophy class? Death is inevitable the moment you're born. So we didn't quite like that legislative wording, so if you turn to page 8, just about 10% down the page, there is a sentence that begins with, "For purposes of this instrument." You with me? "For purposes of this instrument, close to death shall refer to a condition that is reasonably expected to result in my death within 6 months, regardless of the treatment which I may receive." So we ranked up that definition from death is inevitable to death is inevitable within 6 months. Notice this is much more rigorous than the hospice standard, which does not require inevitability within 6 months. It just requires that it's most probable within 6 months.
So it's almost like it being on hospice?
Much more advanced than being on hospice. Because
They have a 6-month.
that it's most probable you will pass away within 6 months. But there are people on hospice for much longer. Death is inevitable. And your mind is gone, remember. So that's another huge difference with hospice. Most people who are in hospice, they have cancer. Yeah. So that's the close to death scenario, okay? The second, turn the page, we get to the second specific scenario, and it's called permanently unconscious. If I am unconscious, and it is very unlikely that I will ever become conscious again. Well, that doesn't seem that rigorous either. Very unlikely. Well, it's very unlikely that Leicester City will win the Premier League soccer championship, and they did. So what we did, and again we turned to page 8, we narrowed that definition. And immediately after what I read before, again, there's a numeral 2 that says, permanently unconscious shall refer to a permanent loss of consciousness, including a persistent vegetative state lasting at least 60 days, from which there is no reasonable possibility that I will return to a cognitive and sapient life. So we said, for you to be unconscious, you have to have been unconscious 60 days. Now, we didn't throw darts at a board and come up with the number 60. Tim Ney in my office talked to a lot of people at OHSU, particularly Susan Toll was kind of their chief, ethics and end-of-life person. And basically, every answer we got is that once you're unconscious or in a persistent vegetative state, your brain starts atrophying. It's lack of oxygen. And really, after a week or two, the probability of coming back, to a regular way just goes away. And so what we did is we took that information, we took it out a long stretch to make it really safe, and put in 60 days. I have clients who are medical providers, physicians, nurse practitioners, nurses. Some of them will ramp it back to 30 days. Some of them will want to ramp it to 15 days, but I generally talk them out of it. I always talk them out of that. I say, look, 30 days, there's something nice about 30 that isn't as nice about 15. And they'll go for that. So that's how we came up with that. So that would mean that you have to be in a coma or a persistent vegetative state for 60 days in order for this document, our version, not the statutory form, to apply. Questions? The third specific situation, this is cheery, isn't it? Is advanced progressive illness. Now, statistically, this is the most common, okay? This is meant to address a dementia. Now, I often find that people have a misunderstanding of the difference between dementia and Alzheimer's, and it's actually really simple. Dementia is a pie, and that pie means that your brain, for some reason, is not processing information really well. And there could be a lot of reasons. I mean, you can be schizophrenic, but that's not dementia. You can be bipolar, but that's not dementia. Dementia is one way that your brain might not be processing information very well. And the biggest slice of dementia is Alzheimer's. But there are other. It could be a result of a stroke. It could be a result of a traumatic brain injury due to a baseball bat or a car accident. It could be Korsakoff syndrome, where there's so much alcohol intake over life that the alcohol ruins the ability to process information. So this is meant to cover dementia, not just Alzheimer's, although Alzheimer's is the biggest slice of the dementia pie. Okay? I'm going to read this out loud because it is the one that we did not change. It seemed to say it all. If I have a progressive illness that will be fatal, and is in an advanced stage, and I am consistently and permanently unable to communicate by any means, swallow food and water safely, care for myself and recognize my family and other people, and it is very unlikely that my condition will substantially improve. The four most important words there are swallow food and water safely. For anyone familiar with a dementia, you lose memory, you lose judgment, you lose the ability to tie, 1 and 2 together, and only at the very, 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 very end does the brain get so scrambled that your motor functions of swallowing go away. Swallowing doesn't require a lot of thought, so think of how deteriorated a brain has to be for a person to not be able to swallow. Okay? Now we turn the page to the fourth and last specific section. Extraordinary suffering. Now, I will tell you that no one has any idea why this is in here. And I've spoken with 2 members of the legislature that were there the year that they did this, and they don't remember why it's in there either. It says, if life support would not help my medical condition and would make me suffer permanent and severe pain. Okay, raise your right hands if you want life support that's going to make you suffer permanent and severe pain and won't help your medical condition. Oh yeah, I want that. We spent a lot of time trying to figure out what the heck they were talking about. We got some theories, but they're not even worth repeating. Okay, so we have these 4 specific situations, and then we have a general instruction which we will turn to later. Now let us turn to the options within each of the 4 conditions, okay? And let's start with the 4th, because that last one's sort of the easiest to start with. You have A and you have B. And A is always about tube feeding, and B is always about other life support, respirator, ventilator. So this goes back to that distinction that I mentioned earlier about how, as a culture, we differentiate between tube feeding and other life support. And how in Costa Rica, it appears to be, according to a hospice nurse who happened to be a client, a customary distinction, perhaps even a legal distinction for all I know. Okay, so in every one of these 4, it's A is tube feeding, B is other life support. Within each of these 3, there are 3 options. Option 1 is, I want it. Yeah, sign me up for permanent severe pain, and it won't help, the treatment won't help my medical condition. I won't. Option 3 is, I don't want it. So those are pretty clear. You want it, you don't want it. The middle of the road option is the one that sometimes takes you down the wrong path. It says, I want tube feeding only as my physician recommends. Or I want life support only as my physician recommends. There's something intuitively comfortable about that. Culturally intuitively comfortable. First of all, we like middle of the road. Like we're wired that way, right? Second of all, we like physicians. We tend to trust our physicians. But look at the word only in here. I want tube feeding only as my physician recommends. Well, what if it's my directive and Sandra says yes and the physician says no? Or Sandra says no and the physician says yes? That word only seems to suggest the physician wins. Well, I know my physician. He's a great guy. I'm serious. But if I'm in a coma, in a hospital, or with Alzheimer's in a nursing home, it's not going to be the same physician. Not to mention that my physician will probably be retired when I'm 92. Plus, I think physicians, like lawyers, are better than average people. Just kidding. I'll tell you a true story. Had a client come in, they were from upstate New York, his dad lived in Atlanta, Georgia. And his dad went into the hospital and ended up in a very crummy end-of-life situation where there was a discussion about end of life. And this is the story my client told me. Now, my client was, what we would call a mensch. I mean, he's not a guy who's going to make things up. He's a totally able guy, okay? He said, told the doctor, Dr. So-and-so, my dad filled out one of these directives when he lived in upstate New York, here it is. And it says he doesn't want to be on these, end-of-life things. And my client told me, so it's hearsay, that the physician looked at it, ripped it up, threw it under his desk in a trash can and said, we don't do that around here. So, how many doctors do you know like that? None, zero. The story is almost not believable, but I do believe it. Because if you live in a country with, 300 million people, there's just going to be some, people who are more than 3 standard deviations from normal. So, I totally have faith in physicians. I mean, every physician I've met has been great. But do you want to delegate this decision, possibly because of that word only, to your physician? I leave you with that thought. So, in extraordinary suffering, you want tube feeding, you don't want tube feeding, or you want tube feeding only as your physician recommends. You want other life support, you don't want other life support, or you want other life support only as your physician recommends. Why don't you initial how you feel about that, or ask me a question, or don't, because your other option's not to do this. Yes?
We've gotten forms from our doctor's office, from the hospital, whatever, that is different than this, different format and all that. But it seemed like there was an option where the health representative in consultation with the doctor. So there was like another middle ground.
So that's the post. Was it pink?
No, it wasn't. It's a booklet. I think Providence puts it out.
Okay. Yeah. Well, okay. So they're definitely. So this
here. This one.
Yeah. Okay. So this is the statutory form.
Okay.
What a lot of groups have done, Providence, Kaiser, this nonprofit, is added a lot of additional things for you to think about and initial in order to facilitate your loved one to make the decision.
So it's the workbook part
exactly.
That has that option, not
exactly.
the actual legal thing.
Yes.
Okay. It'd be nice if that fourth option was part of the legal.
Yeah, but this is legislative. You can add bells and whistles to it, but you cannot subtract from it.
So the option I would be most comfortable with would be my husband making the decision in consultation with my doctor. Is there any way I can add that to this legal document?
Yes, you can write it in the blank that's underneath the general instruction.
Okay.
You could say, I request that my agent make the decision in consultation with my physician.
And then just leave all those blank.
No, well, if you leave them blank, you are what is known in the biz as punting. Right?
Which is kind of what it is, though, because I can't foresee what situation is going to come up, and I'm not going to be able to be involved in that decision at the time.
Okay.
So that decision needs to be made down the road, doesn't it?
Well, the idea is that if you feel comfortable doing it, so this is only for those people who feel comfortable, and I'm sensing you don't feel comfortable doing it. But the idea is that if you feel comfortable doing it, you fill out this document with as much detail as possible so that your husband or your adult child has as much information of your wishes.
And that's where the workbook comes into play, like in that. Right?
Well,
or
the form. So think of Nancy Cruzan. Okay, imagine if she filled out a form that said, I appoint my parents as my healthcare decision maker. Well, that wasn't a problem in that case. Her parents were a healthcare decision maker. The state of Missouri said there's not enough evidence that she wanted to have life support withdrawn. So what if she had filled out a form that said, I want my parents to consult with a doctor, and that's all she said? Would that be an expression of intent that she didn't want life support? No, it would not. It would be an expression of intent that she wants her parents to consult with their doctor.
Now,
So the idea is that you make a decision, and then you can also add, but I want this done, I want the people who I appoint to consult with the doctor.
Now, could you fill out the work or whatever?
Absolutely.
And then like staple it to the document? So
Absolutely.
that, would that be considered, these are my wishes and it's a clear indication of what I want?
Absolutely.
Okay.
When I have clients, like there's some denominations that, theological denominations that have rules, and then we'll staple them to the document or workbook. And what I'll do is just kind of read it to make sure there's no inconsistency, that you didn't check something in the document that says this, and then something that says that they're clearly inconsistent. I mean, they can say, well, this except for this, that's okay, right? But not that they're just ka-chunk and clearly consistent. But but your example is really good. I mean, I think that it would be fair to say that if my spouse or my adult children were in the situation where they had to make this decision, it also would be fair to say that there would be a protocol, right? It's not like they show up one day and say, pull the plug. No, there's regular caregiver meetings, there's experts, there's facility social workers, etc. And it's always done in consultation with professionals. I guess I shouldn't say always, because I can imagine.
You would assume that there's...
Yeah. So there's no harm in saying, I want my family to consult with a healthcare professional or a physician. My point is that your healthcare professional today may not be your healthcare professional tomorrow. That's more likely than not.
By checking any one of these, it takes a decision away from your representative.
On the contrary, your representative is the one that's going to sign the form. Your representative is going to look at this instruction and see whether the situation matches and make the decision. But remember, you appointed your husband, you said he's to look at these instructions and he's to make decisions in accordance with these instructions. And so they're consistent with one another.
So if I said I do not want tube feeding or life support, is he legally required to
honor that? He is, and in fact, on the form he has to sign it saying he accepts. The last part of the form is that he accepts the judgments that you've made.
Okay.
Correct. So the question there is, are the persons who I appoint legally bound by my decisions? And the answer is yes. There's always a little bit of wiggle room, I mean, take that 60-day requirement for a coma. I just mentioned that a lot of people are in coma. A lot of people really, so you could imagine an automobile accident that in addition to putting someone in a coma was so physically harmful that maybe going 60 days is not necessary. So, there's always perhaps going to be a little wiggle room. But the idea is that you follow the rules as they've been set forth here.
If you add extra pages, do the two witnesses need to sign on those pages also?
I think that they should be stapled before the witnesses witness.
So they're witnessing everything and not
Right.
just...
And when we have clients add pages, we have them right at the back, right at the bottom, please see the attached pages. So they witness the whole gestalt. And it wouldn't hurt to have everyone witness everything, but that's not custom. Okay, so we've touched on extraordinary suffering. And any more questions about this A and B distinction? I want it, I don't want it, I want it only as my physician recommends. So let's turn back to number 3. So this one again is advanced, and remember, you're not supposed to check or X, you're supposed to initial. Advanced progressive illness. If I have a progressive illness that will be fatal and is in an advanced stage, and I am consistently and permanently unable to communicate by any means, swallow food and water safely, care for myself, and recognize my family and other people, and it is very unlikely that my condition will substantially improve. Questions? And then the one about that is permanently unconscious or in a persistent vegetative state. and the one above that is the death is inevitable within 60 days. So when this document came out, the idea was you are competent today, put in writing what you want for when you become incompetent. And that way your wishes will be met. And then I went to a presentation by the lawyer, one of the lawyers for Legacy, and she said something really interesting. Yeah, that's a good reason to do it, but really a better reason is that the person who you name is a loved one, and it's going to be an unbelievably difficult decision. So the more detail you give them about your intent, not that it's going to be easier, but it'll be less painful. So you're doing this not for yourself, you're doing this for the others. And to the extent that you don't punt, that you put it more specifically, then it's good.
Where you were saying about 68 something?
Yeah. Page 8. That's not on the statutory form. If anyone's on the video here, it's not on the statutory form. It's just something we put in there. You see it? Okay, so we've gone through the 4 specific situations. Now we're on page 7, and halfway down there's something called the general instruction. So this instruction is here, and I'm going to read it out loud. I do not want my life to be prolonged by life support. I also do not want tube feeding as life support. I want my doctors to allow me to die naturally if my doctor and another knowledgeable doctor confirm I am in any of the medical conditions listed in items 2, 1 to 4 above. Why is this here? It's an expression that basically says, I want to die naturally. If I'm in one of those well, I think probably the reason it's there is because there are people who have difficulty with the specifics of that we just went through in numbers 1 through 4, and it gives those people a chance to complete the form in a good way without having to go through their personal trauma about those specific situations.
So we can skip 1 through 4 and just do 5?
Yes. So your options always are not do it. I do want. Just don't want to do this. Or do 1 through 4, or do 5. Now, for clients who do 1 through 4 and say no, 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 then I also suggest that they do number 5 also, because those are inconsistent. Because another reason this might be here is, well, just as a general statement of intent, so that if, when I first went into practice, I thought we were going to run into cases like Nancy Brazan and Terri Schiavo. And I only ran into one, and it kind of came to a nice ending before it became a problem. But basically, thinking that I might run into those cases, I would be able to put on evidence. Look, this person did 1, and they did 2, and they did 3, and they did 4. And look, they even did 5. Just like a catch-all, So that might be another reason why this number 5 is there. Questions?
So, like I told you, I live in Washington, and so, some of the stuff will be almost the same anyway, so, I'm still working, and I don't plan to stop working for a while yet.
Uh-huh.
But my family all live, my son lives in Sacramento and everything. So, say if I'm all okay still in Washington, should I do it in Washington, and then if I permanently move to California, would I have to redo the papers again in the state of California?
The answer is you should do it in Washington. And if you move to California and take the Washington documents to California, they will be good. But it's still better to do the California documents. And the reason is that if you go to medical person, they're used to seeing their own form, not
Yeah.
the New Jersey form or the whatever form,
Yeah,
right?
and
The
that's.
Wisconsin
that's-
form.
Yeah.
And there are better and worse forms. Oregon has a good form.
No, and most of the stuff would be almost the same.
Yeah, the Washington form is essentially, two forms again, essentially the same. I think the Oregon form is better, but they're essentially the same. So here's another dynamic. If you're appointing, your spouse and then your number one child, the potential for conflict is inevitably much lower. But think of situations where there's a potential for conflict. So those situations are you appoint your spouse who is not the parent of your children and who your children don't get along with. Or you move here from Kansas because you are not in sync with your Kansas family and you appoint a friend here rather than your family in Kansas. In those situations, you would be more careful. You might have a lawyer do it. You might add provisions that say, I love mom and dad greatly, but I don't want mom and dad to do it or something. There are unusual situations. Okay?
I lost my spouse, so I only have one son.
So that son presumably is the most obvious choice, although I don't know, everybody's different.
Yeah. I have a family and one brother and 5 sisters.
So you have to pick your most appropriate symbols. So now we get to page 8. Now page 8 does not exist at all in the statutory form. That's where we define what close to death was. That's where we define the permanent unconsciousness. But this also has other bells and whistles. For example, it says, and I'm not going to dwell on it because it's not in the statutory form, but it also says if you're in one of these situations, you don't want to be resuscitated. It says is, if you lose the ability to process information and you need a guardian, these are the people who you want as a guardian, etc. Then we turn the page, back to the statutory form, other documents. So the Oregon legislature said, hey, you may have filled out earlier forms, particularly a form called the Healthcare Power of Attorney. Do you want it to remain in effect? Do you want to revoke it? Or you don't have it? So you fill that out based on your specific circumstances. And what they're trying to do is make sure that you don't have two forms that are inconsistent. Like, I have a power of attorney naming, my sister Danielle because I wasn't married. Now I'm married to Sandra. And, so I revoked the earlier one. And then you sign in front of 2 witnesses. And then on the next page, the people who you have appointed sign accepting. And they acknowledge that they may be committing a crime by not accepting your decisions. So most documents do not require the people you appoint to sign. When I do a will and appoint so-and-so as my executor does not have to consent. Now, presumably, I talk to him or her, right? But they don't actually have to sign on. Now, if I die, then they do, right? But here at the front end, it's like insurance underwriting. It's done at the front end, not at the back end when the claim's filed. That is the Oregon Advanced Healthcare Directive with bells and whistles. It seems like there's a lot of thinking going on.
I have
Yes.
a couple of questions.
Do that.
So if you were doing the healthcare power of attorney in conjunction with this document, what would make the most sense to initial under 7 then?
The most sense would be not to do a power of attorney for healthcare, or if you have one, to revoke it and to just do this document, because this document is a power of attorney for healthcare
Gotcha.
plus.
Okay. And then my next question, and I don't know if this is a better question for Joel as a medical provider, but under each of these 4 circumstances, would it be safe to assume, now I know not 100% of the time, given the story that you shared, that a physician would most likely not recommend tube feeding or life support in each of those events?
What would the average physician, held to the standard of the community, recommend in each of those instances, assuming those instances were as dire as they are stated here.
Correct.
Joel?
I'd say it varies on where you are in the country and who your physician is.
How about Atlanta, Georgia?
I think your odds go down if they're going to agree with what your wishes are, or in Florida.
So I have been in private practice 30 years in October, and I've only had one problem. I've heard stuff, but it never got to be so bad that they actually came to the lawyer for an express consultation on the issue. So my sense is that physicians in our community are doing what the family wants. Don't mean to slam Atlanta. Been there. Best friend lives there. Great place.
So if, a question, but I'm not sure what they are.
So give it a go.
Well, I want tube feeding, for example. But,
Just like right now,
yeah, that might be good.
save you the trouble of lunch.
Yeah, right.
So this document is not about tube feeding. It's about tube feeding in 4 specific situations. Which of those situations are we talking about?
Well, I don't, here's number 1, that we're supposed to get. But, so, one thing we talked about, and I guess you even nailed it down this yet, over the last several years, that we looked at this and talked about it, is that, so, what a person wants to feed as a trial basis for a week, and it doesn't work, and then how do you deal with the time? So if you say, I do not want it, that means
Okay.
not even for 30 seconds or...
So the question is, what if a person wants tube feeding on a trial basis, for example, for a week, and then wants to make the decision about whether to continue or not? Well, then you do that, because that means your mind is working.
No.
So say you're in the
that-
unconscious state and you can't say that at the
Right.
time.
Yeah.
Well, I think that this applies only when death is inevitable. And so tube feeding for a week just means death is inevitable for 1 week longer. But the decision has to be, the document, or excuse me, that end of life provision only is triggered for when death is inevitable. So you get tube feeding until, under the pure terms of the form, because your spouse can adjust that a little bit, right? But the form's only triggered when death is inevitable. If your spouse says, well, death is inevitable, and by the way, you're on tube feeding already, right? Because they're always going to give it a go, right? It's not, I mean, if you take the situation where, either the Schiavo case or the Kazan case, I mean, in those instances, they were on life support for 5 years before even the process started. Okay? So I think, I'm trying to think of a situation where you're not on tube feeding. So you're in the hospital with advanced Alzheimer's, okay? And you're on tube feeding. No, you're in a hospital, you have Alzheimer's. You have another medical event that puts you in the hospital, okay? And that medical event requires tube feeding. So they put you on tube feeding. And then the decision is to be pulled off. So I'm having a hard time kind of come up with the specific, but I'm sure there must be
So
some.
like
because-
you're thinking like if you had a heart attack and they take you to the hospital and you have they don't think you have a chance of recovering, but you'd still like them to give it a week before they actually turn everything off? Or before they not, like you'd like them to tube feed you for a week just to see if perhaps you do come back?
And then, so then you would like, then, you know, if that's what you worry about, so the document has to meet your needs above everything else. And so you would put a statement in there that you would say, under all conditions, I would like tube feeding to be tried for a reasonable period of time to be determined by my loved one. Something like that? Because we really can't, I mean, you could put a week if you wanted to, but,
And
you
then
know,
that would go
be.
under general instructions number
Yeah,
5.
yeah,
Okay.
yeah. Would that help your situation? But remember, it's within the context of the two doctors saying, oh yeah, death is inevitable. Or, oh yeah, can't. And by the way, anecdotally, over the years, I have run into clients that said, oh, the doctor really wanted to move this along faster than we did. But I've never had clients say, the doctor, beat us, but, no, they always beat the doctor. They said, no doctor, right? Because they were named in the document. They were the surrogate decision makers.
So the family has greater power than the physician at that point.
With the exception, unless you choose that only as my doctor recommends, then it's questionable. But I think, just like Joel was saying, and I agree, I think that in our community, no doctor really is going to want to go and trump the family, whether too much life support or too little life support. I mean, why would a doctor take on that fight, right? In our community, I just don't see that.
Yeah, we talked to her doctor about this and about having the doctor help us make a decision or something, and she said, I don't want to be put in that position.
Precisely. So she would prefer, rather than being the leader, she would prefer being the consultant.
Yeah.
And so the idea is putting your family as the leader. Other questions?
I would just add a comment when thinking about tube feeding. An event in the being on a ventilator. Oftentimes we think of the ventilator as being the heroics and something, big intervention to keep us alive. But if you would die otherwise, the tube feeding is exactly the same thing. It's a smaller machine, but it is keeping you alive the same way the breathing machine would. So the difference is when you withdraw a breathing machine, death comes relatively quickly, within hours or days. With a tube feeding, it would be days or weeks. But they both have the same effect of keeping you alive when you otherwise would naturally not be. And withdrawing them, I think of them as pretty much the same thing.
And so you're highlighting the point that tube feeding and a ventilator respirator are essentially the same thing.
Yes.
And again, it's not about the tube feeding, it's not about the respirator or ventilator, it's about the circumstances in which you find yourself.
Okay.
So if I am in an auto, well, actually, I know someone right now who roughly my age, so let's say middle age, and has been through a series of healthful conditions, negative, and is in the hospital and has been in ICU and out of ICU, now back in ICU, and then what's the care before ICU?
Step down.
Yeah, something like that, just terrible. Well, no one's thinking about looking at pulling anything, because the care is completely, and it can go on for weeks, right? I mean, in our office, we run into hospitals come to us and they say, we've had this person in our hospital for 3 months. It can go on for weeks. So again, this is not a document for when the situation is still in transition, when things can be done. It's for when things can't be done. Question?
So with that, is it safe to say that that means within each of these 4 situations, death is inevitable?
So the first one, by definition, death is inevitable. The third one, Alzheimer's, also is conditioned on death being inevitable because it's fatal, but not inevitable in the same way because a person can be in a dementia on a feeding tube for years.
Sure.
Permanently unconscious, death is, a person can be permanently unconscious forever. So no, they're not all for when death is inevitable. They're all, one of them clearly is, the others are being in a coma or the equivalent, persistent vegetative state, for a very long time, whether you want to be in that. So the idea is that now at age, whatever, you're making the decision about that potential unlikely but possible situation.